you never lived in Bihar? You never lived together in Bihar?
Yes, yes. Only
You
for
said
3
so?
days only at the time of marriage. Only
You
3
said
days.
so?
Yes.
Where did you say so? Let us see that first.
Me rejoined also, my lord.
No. First, show us where you said, because I've noted that you said so, but I don't remember which page you said that. You stated that after the marriage, you and your wife did not live together in Bihar at any point of time.
Only, my lord, only 3 days.
Where did you say that, guys? Just show us where you said that.
This is para, my lord. My lord, but see the para 2. Petition number 1 married the respondent on 27 April 2022 after the Hindu rites and ceremony at Patna, reside together in Patna. This is the address.
No, you also said that you never lived together in Bihar.
Yes, my lord.
Where did you say that?
Even also my rejoinder also.
If you don't know where you said it, say so, we'll search for it ourselves. If you drafted the petition, you should be aware of where you said it.
I drafted.
Then where did you say it?
Hello, can you give a password of
page 13?
I will check.
Page 13. Yes.
A. First. The petitioner number 1 respondent has never resided in Bihar.
Bihar for last 3 years.
This is ground.
Now he's changed. Because she said that they lived together in Muzaffarpur.
Even my lord.
They never lived together. Now he's changed.
Even my lord, kindly see this annexure 2.
Yeah.
That's yes. Page 13.
Page 13.
Page 13. This is ground A. Starts page 12.
Yes.
And then page 13, my lords, he has made A and B. In A, top.
Have never co-resided in Bihar. So you made a specific statement that you never resided along with your wife in Bihar.
Yes.
Now you are changing that.
No. I'm not stating my child.
So she has filed a counter saying that you lived together in Muzaffarpur in Bihar.
Kindly see the connection 12.
Sorry?
My rejoinder. See the annexure 12 and 14.
So now you are saying that you did live together in
only 3 days at that time of marriage, my lord.
She says that you lived together from 2020 till 2024.
No, lord.
Still he is living in Bihar, my lord. We both are IT professionals. We are
Both are working in
Noida.
Noida.
We are working from home. In Noida, in April 2022.
This wrong statement that you
made. Only election 12 of my rejoinder. Her see the location. She claiming the HRA.
Leave her. The lie that you started with in your transfer petition.
My lord, kindly see.
You lied. You said that we never resided together.
At the time of marriage, was a 3 days ceremony.
Petitioner number 1 and respondent have never co-resided in Bihar. This is a false statement that you made. Once you made a false statement, liable to be non-suited straight away.
But it's not a false statement. See the.
You are now admitting that you lived together in Muzaffarpur at least for 3 days.
Mine only for 3 days, my lord.
For 3 days.
Yes.
That doesn't amount to co-residing in Bihar.
My rejoinder, my lord.
3 days you lived together in Bihar.
At the time of marriage.
That is enough. You made a false statement. Once you make a false statement, no question.
My lord, already your own order, lord. Your own order.
By way of this transfer petition.
My lord, see the
petitioner has
own order, lord. Your own order for the same title.
Bihar to Karkarduma courts at Delhi. In his transfer petition, the petitioner specifically stated at page 13 of the transfer petition that he and his wife, the respondent, never co-resided in Bihar. However, after the counter affidavit was filed by the respondent, indicating that the couple did live together at Muzaffarpur in the state of Bihar after their marriage, the petitioner husband changed his stand in his rejoinder and now states that they did live together in the state of Bihar for 3 days. A petitioner who approaches this court seeking relief is expected to do so with clean hands and not by suppression or misrepresentation of facts.
My lord, she
The
is residing in
petitioner,
Noida.
on the face of it,
This will
is
be
clearly
even
found
your own order,
to
lord.
have abused the process of this court, as he did make a declaration which is factually incorrect in his transfer petition. On this short ground, the transfer petition is dismissed. Interim stay dated 9/7/2025 shall stand vacated.
I'm so blessed.
Be a little careful when you do your pleadings, just for the sake of
দেখো আসতে সুটকেসগুলো দাও তো ভাই
এবার কি করতে হবে ওই বিট্টু স্লিপটায় দেখো না কোথায় গেল স্লিপটা
নমস্কার
হ্যাঁ
আমি জানি ওই স্লিপে কি লেখা থাকে আমার সঙ্গে আসুন হুইল চেয়ার এটা আপনার আর এটা আপনার স্লিপে শপিং এর কথা তো নিশ্চয়ই লেখা থাকে একটু পেট পুজোর কথা স্লিপে থাকবে না এটা হতে পারে
টিফিন এনেছি তো
থ্যাংক ইউ
আরে এই তো স্লিপটা
স্লিপে তো এসব কিছু লেখাই নেই
আমরা আছি তো আপনার স্লিপ
শুধু ওয়ার্ল্ড ক্লাস এয়ারপোর্ট চালাই না
Yes,
Yes.
you permitted by you, lordship.
sorry,
No, lying
lying is permitted. He said lying is permitted.
No,
Then?
I'm asking. I'm not lying.
Well, you did lie.
My lord,
There
no,
has
she's
to
the
be-
PM.
mentioned in the petition that he got
Sorry.
married in Bihar.
Bihar only for 3 days, lordship. This
There
because
is
the
a
custom.
question. You said you never co-resided. 3 days you lived together, that is co-residing. You didn't get married and leave in the evening.
Your own order, lordship.
Next matter.
Well, same jurisdiction, my lord.
Counters filed. You filed a counter.
Please, my lord, I am for petitioner.
Yes,
The state has filed counter, my lord,
yes.
and there is no eyewitness. It has been stated by the state itself. I have undergone 6 years and 6 months, your lordship. Out of 24 witnesses, only 4 has been examined. And in this matter, my lord,
What is
kindly
the-
see the state.
Filed.
There are 24 prosecution witnesses, Lordship. 4 has been examined.
4 have been examined out of 24.
Yes, Your Lordship. He's undergone 6 years, 4 months, 17 days.
No eyewitnesses.
No, Lordship. I have gone through.
And what time was she found?
uh,
Why?
When the father reached the house, she was found on the bed. The accused and all the family members had already absconded. So only the husband's name is there in the charge sheet. The name of the brother-in-law, mother-in-law, father-in-law, and sister-in-law were removed.
Exonerated, your lordship.
They all
Initially, their name has been mentioned in the FIR.
But the others are all exonerated.
All of them are exonerated except for the husband. When the father reached the place of occurrence, they had all of them had absconded.
And what time was that? The
Uh,
morning, night,
Morning, Lordship.
morning.
In fact, your lordship, deceased has committed suicide because she has not get any child after marriage of more than 7 years. And this is the statement of the father, my lord.
Anti-mortem strangulation is the cause of death,
Yes, Your Lordship.
not hanging. Strangulation.
Strangulation, your lordship. This is
Strangulation
on
is different.
page
Strangulation
19, your lordship,
implies
page
use
19
of
statement of the
hands
doctor.
Or a rope, some such implement. She was strangled to death, not that she died by suicide by hanging. Anti-mortem, the postmortem report says so.
Yes, Your Lordship.
Anti-mortem strangulation.
I've also brought on record the doctor's statement from the relevant paragraphs of the case diary. It says.
Was there any rope or something found there?
No,
Nothing
no,
of
Your
that.
Lordship. In fact, her bone was
Sure,
found.
is the postmortem report,
Lordship,
postmortem report is also filed?
I have filed the statement of the doctor.
Doctor is there?
Yes.
Where is it?
Your
Lordship.
lordship, this is on page 19, annexure R2, then counter affidavit, my lord.
19.
Page 19, 19.
Last 2 sentences, Lordship.
Died due to strangulation. We will only ask the trial court to expedite the trial.
Lordship, I have already
Merely
undergone
because
more.
there's no eyewitness
My,
doesn't
my
mean
lord,
that
my lord, kindly
What?
consider this is not a question. Your
Despite
lordship,
the
your,
length of incarceration suffered by the petitioner. The postmortem report clearly indicates that his wife died by strangulation. And he is the only one facing charges in that regard. The specially petition accordingly dismissed.
your lordship, kindly 1 minute, your lordship, this is your lordship judgment, criteria of judgment, your lordship, when trial has been not concluded within 5 years. Kindly, your lordship, consider. Kindly, because petitioner has no criminal incident, because wife has committed suicide.
Granting unnecessary adjournments, either to the prosecution.
Your lordship, I am never taken any adjournment.
Grateful.
Then your lordship, kindly give me liberty, at least if trial has been not completed within certain time, then I
No,
have
no, we
filed
are not
again.
fixing a time frame. It will have to be.
Your lordship, kindly consider, if your lordship
We've
dismiss
said
this
that
matter, then I will,
thereafter you can
your
file-
lordship, then I'm seeking to withdraw my lord.
Item 4, my lord.
Item 4, my lord.
There is a 4.1, my lord, your lordships have issued and tagged it along.
Yes.
If your lordship permits me, give me 3 weeks' time, I'll file a formal counter because the same ground.
Both of them are perhaps
Yes, yes.
stand on the same footing because coexist, no doubt.
Yes.
But the person in the petitioner in 4
Yeah.
was out on bail when he's committed this offense. The second man perhaps was not.
I don't know, my
convicted
lord.
earlier.
That's exactly what I want to find
No,
out. If there is any
going by the order also, he said that I have no criminal antecedents. 4.1.
4.1, I don't have the brief, my lord.
You don't have the brief
I don't
also.
have the brief.
Then,
That is why.
Next.
Or you
or
lordship,
in any event, you're not entitled to. You violate the condition of the suspension of sentence. You've already been convicted.
No, my
Come out on bail and then you violate it.
My lord, it is, the appeal has been allowed, my lordship, in that matter, my lord.
Appeal is allowed. That doesn't mean that you still get the benefit of violating
No,
the
my
bail
lord,
condition there.
my lord, kindly see the
When
annexation
you
of FIR.
were caught in relation to this offense,
I go down, my
you
lord.
were out on bail in that criminal appeal.
My
You
lord.
were out on bail.
The whole FIR
And
is
you are
quoted, my lordship.
stated to have again indulged in the
For
same
a
act.
moment, my lordship, kindly see the
Commercial
FIR.
quantity, 42 kgs,
For a
by the way.
moment, only FIR, my lordship.
Anyhow,
And
we'll
the
live
counter-
to see another day. Let the counter come in 4.1.
Only the
Then
counter.
we'll see. Learned counsel appearing for the state,
state, my lord.
state of Tamil Nadu, seeks some time to file a counter affidavit in SLP criminal number 17208 of 2025. Beautiful order. Based on 18 December.
Like,
My lordship, I allowed to be appearance slip.
Item 5.
Your lordship, in item 5, I'm being led by my senior in some medical difficulty.
Sorry?
In item 5, I'm being led by my senior in some medical difficulty.
Medical difficulty.
Medical difficulty. I'm paying for some accommodation.
How much time do you want?
Your lordship, any date next week?
Next week, I should take it up tomorrow, day after, it's Friday, I should take it up. Next week, I am in a difficulty.
They
have,
What is wrong with the council?
matter has been adjourned for 5.
He's having some pain in
four
the
times.
neck. He cannot sit. There's some. That's why he cannot. It's very difficult for him.
Yeah, it's a
I'm in-
302 matter.
I'm in lots of time, but it's 1.5 years have gone by almost. 1 year.
Based on 8th December.
Too big.
The request to the learned council for the respondent. State.
8 December. 8 December. Lots of fixing 8th.
8th is
Too big.
Item number 6.
8th is Monday.
What is it?
yes. Counter 5.
Let me file an additional document as well, Malach, stating the stage of the trial, Malach. 11 witnesses have been examined. Now it is at the stage of defense.
11 out of 14 are.
3 have dropped few, Malach.
3 approximately.
Yes, sir.
So
Now it is
trial
at the
is
stage of
almost- State of
the defense evidence.
defense evidence.
Next date is 27th November. He has 12 criminal antecedents, Malach.
11.
12, 11.
11 or 12?
11, my lords.
11.
It's 11.
11.
My lords, 1 year, 1 month. has
No,
been-
the trial is almost over.
For defense witness.
So of course, earlier NDPS cases also involved cough syrup only, or he was dealing with some other thing.
Malach, that
There were some
because we couldn't get the FIR.
No, but when you give the details of the
My lords,
earlier cases.
my lords,
you can't-
three of them,
Just a
my lords, three cases.
counter perhaps.
Was IPC. One was for the Public Gambling Act, and
Two,
two of them.
three were NDPS.
Yes, my lord.
Or this is the present case. So two other ones.
Two NDPS.
Two were NDPS. What were the drugs that you were dealing with there? You should know. What was your client dealing with there in those cases?
My lords, one what I know of was ganja.
Ganja.
Five
Then
5
one?
kgs ganja, and in Drugs and Cosmetics Act.
No, the other NDPS. There are two NDPS. One in 2012, one in 2015.
My lords, 2012 one I know, my lords, ganja. It was.
It was an NDPS. He's regularly involved in these activities. He's selling to the young people, and they are further selling it to the in the society.
This cough syrup, we are in the process of hearing that batch of cases. 16 bottles.
Well, it is 1600 grams. So 1 kilo is the commercial quantity. He's caught up with.
No, that you will have to look at the amount of codeine phosphate, is it not?
Well, it is a judgment. Well,
There seems to be a notification of the government of India saying that in an undivided preparation.
It says that the neutral substance cannot be excluded. It has to be seen.
But if the government itself comes out with a notification, there's a government notification. Are you aware of that? There's a government of India notification saying that in undivided preparations, if the codeine phosphate is up to a particular level, it will not come within the scope of NDPS.
Even at the
So we don't know what these 16 bottles, how much was the percentage of codeine phosphate?
It makes it worse. The neutral substance makes the drug worse.
Once there is a government of India notification, you can't argue against it.
Yes,
if the GOI in its wisdom says that this will not come within the scope of NDPS, so be it.
I have to see that, but he has prior.
Are you aware of that notification?
Yes, my lords.
What does it say? 2.5%.
Yes, my lords.
2.5%. We don't know what the percentage here is.
My lords,
does it indicate?
Either,
does your FIR indicate the percentage in the bottle?
No, my lords.
Cough syrup normally contains how much? I don't know.
I have to see. I'll just see and come back.
Most of these are fensidyl, I think. Fensidyl cough syrup. So immediately, if you can find a medical shop, see how much fensidyl has.
I'll just find it online.
First over.
Yes, sir.
May please, Your Lordship.
Counter affidavit not filed.
Please, Your Lords, I appear for the respondent number 2. Your Lords,
R2. Who's appearing for R2?
Your Lords, I appear for R2. The R2 is trying to source some documents. Your Lords, we will do the needful within the week, subject to Your Lordship's graciousness, Your Lords.
State also has not filed yet.
No, lordship. I'll also need.
Then council appearing for the state of Uttar Pradesh and the learned council appearing for respondent number 2 seek some more time to file the counter affidavits. Usual order. List on 12th January.
Highly obliged.
Great.
Adjournment is sought by the learned council for the respondent to file a counter affidavit. Usual order. List on. This is a.
Bail minutes.
What are the offences? Hurt. Attempt to murder. Very. List on 7th January.
Lodges.
So counter affidavit.
For the accused, I filed my Pagalakama day before yesterday only.
State has filed a counter?
Yes, we have filed
You
yesterday.
filed it.
Well, I may be granted.
Yesterday?
Yesterday we have filed. It may not be on record.
Then council for respond number 2 seeks some more time to file. You first entered it.
First of all.
You filed your wakala?
Yes, not day before yesterday. It's there in the office.
That he entered appearance day before yesterday and seeks some time to file a counter. Usual order after that. 8th January.
Since the trial is going on, would you lot to consider hearing on that day because the witnesses are now being examined. That's why we.
Lord, I have been summoned as an additional accused in 319 CRPC. I was not an accused during investigation even. There was a closure report and.
No, but the order is the template order that is being. followed by the Allahabad High Court.
My lord, I
Somebody needs to tell them to at least change the template once in a while.
that we have unfortunate.
Overcrowding of jails,
I may not be, my lord.
template orders and transfer
that
petitions,
your
it's all right.
lordship
We
is
also follow that.
That your lordship.
But in bail matters, at least you should not be
Lord,
following
I
a
bowed down,
template order.
I may not be to send behind bars.
Whether it's a
The lady, my lord, will be
302 matter or a 323 matter, overcrowding of jails.
My lord, that's incorrect. Lord, I bow down, but my lord, the lady accused may not be punished for that. That is the I.
Very well, you file your counter.
I will file our reply. Much of it.
Item number 10 has been PC.
May it please, sir. My lord, it's unusually long, my lord. I wouldn't have come and bothered your lordships, but I must tell your lordship, not
What is this order though? What are you
My lord,
agreed by?
my
One
lord,
order reserves judgment.
I didn't know how to
The
come, my
other
lord,
order is
either.
an order of adjournment and you have to file a
My lord,
report.
either I
What is
come
it
in
that you
Article
want us to
32,
interfere with?
my lord, either I come in 32 or my lord, I had to file some SLP. Allow me just
But
one moment to
Your
give your lordship's ground reality, my lord.
reserved, is it?
My lord, it was reserved after 1.5 years. After reserving, it is again listed. When it is
For some
listed
filing
in
of a report, we can't say that.
No, my lord, allow me just,
We
no
have
report actually, my
allow
lord.
some play in the joints even for the high courts. If the learned judge has a doubt and reopens the matter, we are happy to
My
find.
lord, allow me just one moment. Actually, my lord, no report is now taken, and from then onwards, my lord, reserved was on 28th July, relisted on 17th October. After 17th October, it has been listed
31st
now.
October, it was supposed to
Now, my
come
lord,
up. What
5
happened on
times.
that day? What happened on 31st October?
Nothing happened, my lord. Not even taken
The
up.
report was not filed?
My lord, matter not called out. And after that, 4 dates matter not called out because the my lord court master says this is only for pronouncement and it will be pronounced. So my
But
lord,
these
matter
are
is
not
not called
orders
out.
that we can interfere with, Mr.
So my lord, I can only say, my lord, 2 orders I want to show to your lordships, my lord. Punjab High Court itself, your lordships, my lord, said that this practice, my lord, Punjab High Court, your lordship said, my lord, and had given a direction, a bail pending since July 2024. Whether, my lord, allowed or dismissed is, my lord, another thing. But, my lord, your lordships have now passed directions, my lord, that it should be decided. Hussain said 1 week. Satinder Antil said, my lord, 2 weeks. Now, my lord, recently, my lord, Justice Patiwala's bench said.
High Court, sir. I didn't understand that. You go to Rajasthan High Court, you also before Punjab and
No, my lord, it's the bail is only before Punjab High Court because
No, but
SFIO case is in Gurugram. The
You see
original
the-
case is in Jaipur.
You obtained interim bail from Rajasthan High Court on 7th August.
My lord, that's an interim bail application because I'm confined in several jails.
How is it that you are going before both
No, my
courts?
lord, no, my lord. The High Court has granted bail in all cases to him because of, my lord, peculiarity of situation. He was, my lord, medically ill. He's a senior citizen.
Well, he didn't undergo the surgery for 1 year. That's the reason why it was cancelled earlier.
No, my lord,
I'm on the ground that he's going to undergo that surgery, and then he doesn't undergo the surgery for 1 year. Thereafter,
my lord,
he's
there are,
recalled.
my lord, several.
Again,
He indeed has undergone something, my lord.
Rajasthan High Court.
What today, my lord, that's
What's
Rajasthan High
happening?
Court is not under consideration. Under consideration, my lord, what Punjab High Court sitting over a bail order, my lord, for so long. My lord, I am only telling your lordship, my lord, and making a responsible statement. The matter is not being called out. It is not being called out.
We are not inclined to interfere with the impugned orders in the light of the fact that the Punjab and Haryana High Courts, a learned judge of the Punjab and Haryana High Court seems to have reserved judgment in the matter by the earlier order dated 28/7/2025. But the matter seems to have been reopened for the purpose of enabling the filing of a report. As the learned judge would be pronouncing orders having reserved judgment in the matter, we are not inclined to interfere at this stage. The special leave petitions accordingly dismissed on that short ground. So you can show it to the learned judge and say that.
My lord, I only say, my lord, your lordship, one word, that, my lord, your lordship.
हाँ बोल बेटा करण।
क्या? जिंदगी की रोज की दौड़ में हम अक्सर चीजें भूल जाते हैं।
अंकल!
पर अच्छा लगता है जब कोई आपका ख्याल रखता है, जैसे कि आरबीआई ख्याल रखता है आपके अनक्लेम डिपॉजिट्स का।
अनक्लेम डिपॉजिट मतलब?
वो बैंक खाते जिसमें 10 साल या उससे अधिक से कोई लेन देन न हुआ हो, ऐसे खाते आरबीआई के डीईए फंड में चले जाते हैं।
अपने बैंक के किसी भी शाखा में जाकर अपना केवाईसी अपडेट कराइए
और अपना अनक्लेम डिपॉजिट वापस पाए।
आरबीआई कहता है जानकार बनिए,
सतर्क रहिए।
Small bottles, lots of ink, lots of prints. Fill, forget, and keep printing. Epson EcoTank printers. It's
the other co-accused in this matter, namely Mr.
You were absconding since 2018, though.
Your Lordship, but we were present on the production warrant, on the first production warrant, and Your Lordship, we have
The FIR is of 2018. You were arrested only in June 25.
Your Lordship, but the other main accused have been enlarged on bail in this.
That doesn't mean that you just. Where did you go off to?
Your Lordship.
Charge sheet is also filed, but you have not filed a copy of the charge sheet, so we don't know what it says against you. So this selective filing of documents is, of course, very popular here, but we'll have to take at least draw an adverse inference once you don't file a relevant document. You've not filed a copy of the charge sheet. You say that the charge sheet is filed.
Your Lordship.
You're obviously shown as an accused there because you've been arrested. So we don't know what the charge sheet says against you. You don't want us to see it.
Your Lordship, please give me please one short date.
No. That building up the case as you go along, that is also not permitted.
Your Lordship, but we have been enlarged on bail in other similarly situated.
We find no good ground and reason to interfere with the interim judgment passed by the High Court, especially petitions accordingly dismissed.
Item number 12.
Adjournment is sought by the learned counsel for the respondent to enable him to file a counter affidavit. There's no interim order. No interim order.
Lordship, in item 12, I beg to appear on behalf of the petitioner.
Date and 19.
The TCR also was requisitioned in the.
Sorry?
In item 11, TCR also was requisitioned. That may also be taken.
In item
11 months.
11?
Sorry, item 12 months.
12?
TCR also was requisitioned, but it is not received so far.
That was asked for.
Yes, ma'am. With a previous order, it was asked.
Which order was that? Maybe asked for key copies of the trial court records.
Yes.
That was long ago.
Long
Not been requisitioned till.
It was requisitioned, my lord.
What does the office report say?
From the office report, para 5. Requisitioned as earliest in 2110.
Registry shall follow up and secure the trial court records from the High Court, public trial court, as expeditiously as possible.
Public.
Pleadings may also be completed, Lordship.
Sorry?
Pleadings may also be completed. Counter was directed to be filed, not yet filed.
What
Yes.
pleadings?
No, Lordship, I recorded in the last order that counter was to be filed. They prayed for time, not yet filed.
To do. That is the reason why we are adjourning the matter to enable the
Yes, Lordship.
file a counter.
Great.
Great.
We joined
It's also incomplete, I was told.
Sorry?
Service is also incomplete.
Service is incomplete.
That's what I was told.
Yes.
Office
We are,
report 6
we are
minutes.
taking fresh steps, my lord, by the state today.
Service shall be completed on the unserved respondents by the next day. Who's unserved?
2 and 3.
2 and 3.
2 and 3. 1 and 3.
Sorry, 1 and 3.
We have for 2.
1 and unserved respondents.
Great.
13, adjournment is sought by the learned counsel for the respondent. On the ground that the learned counsel, on the ground of personal difficulty. However, we find that the counter affidavit has not been filed. File a counter also, please. We find that the counter affidavit has not been filed till date. Needful in that regard shall be done within 2 weeks. Rejoinder thereto, if any, may be filed within 1 week thereafter. Within 2 weeks thereafter. List on 27th and
Please.
Item number 14.
This matter replies awaited.
My lord,
R2 is not served.
I beg to appear on behalf of R2.
R2 is
By
it?
the my lords, I filed my wakalatnama during the course of the day.
No.
However, last order indicates, my lords, that we can make an attempt for settlement. Should the other side be willing, my lords? I'm willing to participate in the mediation before Supreme Court, my lords.
Yes.
In fact, the notice itself says, notice order.
If it's a date, we'll ask for that.
Very good. Mediation. Okay. This, both parties are here.
Yes.
I appear for respondent number 2, Khushbu Garg.
No, where is she?
My lords, she's in there.
Rishikesh, my lord.
Rishikesh.
Yes.
Sorry, Rishikesh, my lords.
Weekend would be better or a weekday? She works?
First one can be be virtually and then we can decide the
Very
mode of mediation, my lords.
Then 3rd December at 11 a.m.
Very good.
Physical requirement, my lords, they can be the first of it.
Sorry?
Should there be any physical requirement?
Thereafter,
My lords, if my lords can indicate it in the order, my
you
lords,
need the expenses
yes,
to
the
be taken.
expenses to be paid. My lords.
If she needs to come physically, you will bear the expense.
I don't mind, but she is updated with the maintenance part, my lord, and her mother, her aunt is
You want to
residing.
settle or you don't want to
Settle.
settle?
I'm agree with you.
Then you should, that all goes.
Grateful, my lords.
Very good. Blessed.
Item number 15.
May I please?
Yes.
If your lordships could grant me a short passover. Actually, I'm led by Mr. Deshmukh. He is on his
You've received a copy of the counter?
Well, sir, the counter has been received by them. They had taken some time to file a rejoinder. However,
Not filed though.
no.
not filed.
You don't need to file a rejoinder?
I have no instructions as to that, my lords.
Well, you did take time on 15th April for a rejoinder,
I'm aware, my lords.
but then we take it that you don't want to file a rejoinder.
No, my lords, I would like to seek some instructions from Mr.
Why didn't you ask for the instructions before you came here then?
No,
If you're aware of the fact that the earlier order records that you were granted time to file a rejoinder, then you must ask your colleague, your senior, whoever is, you're attached to the office of the arguing counsel.
Yes, my lord.
Then why did you ask him then? You feel shy in front of your senior. Scared or shy?
A little bit of both.
Both, is it? But you're brave before us. It should be the other way around.
Forgive me, my lords. A short passover would be.
What for? Again, your senior will come and ask for time to file the rejoinder. We find that the rejoinder has not been filed till date. Last opportunity is granted to do so before the next date of hearing. List on 90. This is perhaps a matter for hearing.
Yes.
You want some monetary benefits or something?
The petitioner, yes.
20th January.
Recognized, my lord.
Please, sir.
I'm appealing for the private respondent, Your Lordship.
Yes.
Your Lordship, his son died due to negligence in the army hospital. Item 69 of Your Lordship.
Some judgment is also there is what they are said.
Yes. In item number 16, I am requesting for a passover. We are led by Mr. Banerjee in this matter. He is in court 8.
You are for the petitioner.
For the respondent, Your Lordship.
You should be here.
Yeah,
Unless you've changed your identity, you want to go there. You want to pass over?
I will be having difficulty in case it is passed over. They will be.
Then we'll give you another date. When do you want?
Your Lordship, any other date will be given, maybe next week, Tuesday or then.
Passover sought by the learned counsel for the petitioner, but the learned counsel for the respondent states that she would be in difficulty. Matters accordingly adjourned. List on. This will take some time.
It takes some time. We'll take.
You say that it's covered though.
Yes, Your Lordship,
Yes,
have
my lord.
judgments in our favor.
Your Lordship, judgments are in my favor. Your Lordship, it will take some time.
Take
There
some
are
time.
plenty of judgments.
Then we'll give you a Tuesday.
In case there is a negligence.
Third
of
February.
institution, then like.
Item number 17.
Please, your lordships.
Yes.
Madam, in fact, this raises an interesting and an important question which your lordships had actually summarized while issuing notice in the matter, my lords. And what arises for your lordships' kind consideration is the issue that
What happened to the order? It's come?
none of the plan has been approved.
Resolution
So
plan.
that's the plan has been approved. Now, I'm really not even concerned with it, my
You
lords.
want to set off during the
Only,
application
my
process.
lords, and may I only add, I am not for a minute even suggesting the law is no longer recent the issue of that even if an arbitration proceeding were to decide an issue, it cannot alter the plan. Your lordships have said two things. The arbitration proceedings can go on, but they will in no way alter the plan, because as far as the IBC is concerned, that will have an overriding effect.
Mr. Kaul, it's better perhaps we take up this matter on another day, Wednesday or.
Very well, my lords, whatever your lordship says.
Sorry, today is the Wednesday. So,
because
but we've got a crowded hall because of the West Bengal matter.
I appreciate that. All that I am requesting is, my lords, if your lordships could consider any Wednesday for the matter that it has some bearing on the larger issues. And secondly, other than that, my relief is very limited. I am neither saying that I will claim anything against the corporate debtor even if I were to succeed. So I am not on the alteration of the plan at all. My limited relief is that it can't happen that you don't give me a value to my claim in the IBC. The corporate debtor proceeds against me in the arbitration, and I, even to the limited extent of a set-off being claimed in an arbitration, can't claim that. And even when your lordships dealt with the judgment of Airtel, where your lordship said a set-off in an IBC. Mine is not a set-off in an IBC. I'm claiming it in the arbitral proceeding. Even in an IBC, your lordship said that ordinarily no set-off, but if it's a contractual set-off, or it is so equitably intertwined in the same contract, the two transactions, that we can look at even under the IBC. In Airtel, it was held to be two separate contracts between Aircel and Airtel. But I'm not even claiming that. It's not that I filed a claim saying that you owe me 20, I owe you 100, so 80 is the figure. I'm just saying that let my set-off be there so that if I succeed and my claim is more than yours, I don't enforce it. But if you succeed against me as the corporate debtor or as the resolution applicant, then if my claim is 50 and yours is 100, I get a set-off of 50 and you can only claim and execute 50 against me. That's the broad issue.
The broad issue is when there are concurrent findings of court, your lordships, including in the recent BPSL judgment, which we both were on the same side, have said not to interfere. Notice of arbitration, this is already raised in arbitration. It's an indirect way of not touching a...
Well, the same thing was said on the first date of concurrent issues. I said with some, you are pointing out what was already pointed out. And on the first day, my lord, the Chief Justice...
We'll take it up on another
Yes, very well, man.
Another Wednesday.
Another Wednesday.
Another
Wednesday. When the court is a little less crowded so that you won't have to sweat. Though it's winter, I think already the temperatures are rising. So...
My lords, would your lordships be kind enough to give a specific date?
We'll give you a specific date. Do you want it this side or that side?
January, my lords?
January, yes. 21st January.
Grateful.
This is for hearing on.
21st? My lords, could it be a week later or a week earlier? Whatever your lords. 28.
28.
Grateful.
18.
या तो मुझे एक हफ्ता बाद दे दो या एक हफ्ता पहले दे दो.
Not complete. By the time service is completed in one matter, one more fresh matter is added. So there's again an issue of notice.
May I suggest? They are all...
You keep on filing more and more cases. When will the matter ever be heard?
We are doing that the same law, but by that time every
you file a fresh case again. Now that
item
which has been tagged, that's against state of Kerala.
State of 23. I'm 23.
So you have a batch of cases and you're bringing each one into the pipeline now.
Installments.
So by the time the service is completed in the first one, there's a last one which is added where the service will have to be completed. And they're all tagged together, we can't take up the matter for even hearing on interim relief without.
But one matter, if it is notice complete, we can take it up.
Sorry?
If one matter notice complete below.
No.
Otherwise,
they're all tagged together.
That's right.
Once they are tagged, we can't grant an interim order in relation to a matter where notice is yet to be served.
The threat of a contempt
that is not possible. So, stop filing, perhaps complete service, then we can hear it. Don't file any more now.
Let us see.
Please wait till you finish your arguments on the interim relief, thereafter.
I understand.
So, as per the office report, dated, just give the date. Service remains incomplete in some of these matters. Steps shall be taken to complete service in relation to the unserved response. This from 4th February. 4th February.
Can it be January below so that
you have to complete service? There are quite a lot of respondents there.
We are taking all of it below. That's this is we are doing it.
21st January.
apply.
Lord, we beg to appear in.
To take up each matter separately.
Yes.
So all of you don't have to start shouting at the same time.
Yes.
It's
And
the only
we will
way.
take
each item, one at a time.
very well.
So first 19.
19.
May I please start?
19 is okay. Yes. Vivek Pari.
In this matter,
Now,
the process has
no, the grievance in this was that the new rules were sought to be applied to the
45
unpainted
marks.
candidates.
14.26.
And we granted an order for
We were
to
permitted to
So
participate.
you,
Now the results have come along yesterday, and the procedure as per the schedule as fixed has been completed. May I suggest, my lord, this matter may be called up after the procedure.
why should we keep it though?
No, my lord. The reason is this, my lords.
This is a different one. Arunima Paul was, I think, a little different because there, she was one of the tainted they come out with fresh food.
They announce your result. Your interviews will go.
We want to establish two people. That will be 50%. So they wanted to apply the listing so that you're not eligible. So that we said,
এখানে এসএলপি তে আমরা রেসপন্ডেন্ট কোথাও নেই এসএলপি হচ্ছে it has to be a finalized clarification
and judge there and JB seems to be entertaining the petition and the remainder so it's is that some of the cases can use the body and the list of patient candidates is not being put in a public domain already. We should look into that. So in the first place, the revision will help us framing laws to ensure that changing candidates don't come here. If the government is taking up such matter, we don't have to do this. So you let the they can become better than this. I also give
It's on 21st August 2025.
There's one aspect though.
Yes.
The reason why we kept it pending was
Because
to see that tainted candidates don't slip
eliminated.
don't slip through. Now we find that the High Court has taken up that issue in a writ petition, which is
No, my lord,
pending.
the scope of the proceedings in the High Court is slightly different. We were all
Then-
people who were allowed
then
to.
this issue is also being looked into as to whether tainted candidates have gotten.
My lord,
That issue is, yes, no,
That order is there.
no, my lord, the other issue, may I just clarify? My lord, there is,
We already said that all of you will not speak at the same time.
Lordship, the High Court is in season of a matter where those who are not eligible under Lordship's direction.
All issues seem to be there. We will say that the High Court will look into
No, my
all
lord,
issues.
what would happen then
It
is.
would be better that the High Court, being the court of first instance, looks into it. The only
No, but
reason we
Lordship,
kept
my
this
what-
matter pending
Lordship,
was at that point of time, the High Court was not seized.
No,
of
my
it.
lord, insofar as.
Now the High Court is seized of a matter where this issue
No,
is
my
also
lord,
being
this
raised.
issue, qua
Last item.
Lordship's 20. Lordship should kindly see the. One the going.
Item 20.
Item number 9.25.
Lordship should kindly see a IA that we filed. Lordship should kindly see.
It's better that the High Court decides all this matter. It should be counted, Lordship. Item number 19.25, Lordship. Mukleshwar Ahmed.
Lordship, may I just place this one? We have moved an IA in this case, moving on record a summary of the issues before the High Court. Because the earlier challenge was on multiple fold by tainted candidates also. And the.
Candidates which means will not be permitted to participate. Here the thing commission published this unfortunately because they are if you look at the order passed by Justice Amrita Sinha, if you look at that order, attention of this court has been drawn to the order passed by the Honorable Court wherein there is a specific direction that candidates whose names appear in the list of tainted candidates will not be permitted to participate in the recruitment process. Prayer has been made to direct the Commission to publish the tainted list in such a manner so that the identity of the candidates can be properly ascertained. So this issue is being looked into.
But we will another.
So far as the tainted candidates,
Our tainted candidates, this is our special petition. Why? Kindly see, this is
We will not interdict the High Court from looking into all issues.
No.
Only
My
whatever issues the High Court.
My lord, that is correct.
our petition.
One issue
This is
here,
our
because I appeared before the High Court.
This-
There is one set of issues which pertains to tainted, untainted, so on and so forth.
Bro,
The
this is our
second set of issues which your lordships have already taken note of and adjudicated upon is prior weightage. Meaning 10 marks prior teaching.
No, that is not even before.
Yes, no.
That is what the High Court
Said you will not apply the new rules to the
Yes.
untainted
Yes.
candidates.
Yes.
So as to keep them out as
Your lordships will
How
clarify
you have
that.
The court only considering the constitutionality of the new rules.
Yes.
Any will also get the weightage mark.
Can I pass on? Can I pass on?
So benefit
No, no, the High Court is
Yes, my
considering
lord.
the
Yeah.
constitutional validity. That cannot be interdicted at
qualifies
this
for
stage.
calling for interview or add it only at the stage of
These
interview.
two
We
questions.
get filtered out. Not even at the inception.
But
No,
on.
now that the High Court is seized of actually, how many matters are pending?
kindly.
My lord, the
You know, why are they scared of going to High Court? I don't know.
This is our special
Your lord, if you could just.
We are not going to stop the High Court.
No. I am not. But there is a finding. Can you see? Hello, excuse me, sir. There is a clear finding that the physically disabled persons who are in the tainted list, they will not be allowed to appear in the examination. But your lordships have said something else in your lordship's judgment.
No.
Kindly see.
We have never said any tainted candidate will be allowed.
Physically disabled.
Physically disabled, untainted candidate. I remember distinctly, Dr. Mukherjee appeared.
Yes.
Yes, Lordship.
Tainted means tainted.
They stand on the same candidate as that
Can I place that paragraph to your lordship? Kindly see.
You get the benefit of 7 years.
Kindly come to page
Job.
60.
The High Court is interpreting the order.
Page 60.
Yes.
Paragraph number.
Page 60.
Yes.
Paragraph 47. First I read, then paragraph 48. Some of the appointed candidates who do not fall in the category of tainted candidates may have previously.
What is the other issue? That is with regard to going back to the.
Kindly come to page 48. Paragraph 48. Later we address the case of disabled candidates. Our attention has been drawn to such cases where the improved judgment held that the appointee Mr. Somadar shall be allowed to continue on humanitarian ground while we will not interfere with the findings. We will make it clear that other differently capable will not be entitled to same benefit as would contrary to legal principles. So, however, in consideration of disability, these candidates will be permitted to continue and will receive wages until fresh selection. Next, paragraph 49. These disabled candidates mentioned in the previous paragraph will be allowed to participate in the first selection process if required with age relaxation and other concessions. But if your lordship,
Looking for attractive savings options? LIC presents Nav Jeevan Shree's single premium plan. Deposit lump sum premium amount. Enjoy life insurance cover. Get guaranteed fixed amount on maturity. Liquidity options also available. Buy now. Attractive rebates for existing policy holders. Terms and conditions apply.
हेलो नमस्कार, आपको हमारे एक्सक्लूसिव प्री लॉन्च ऑफर के लिए चुना गया है।
ये एक स्पैम कॉल है। आप भी ऐसे ही कॉल को बार बार काट देते होंगे या फिर फोन पर ही ब्लॉक कर देते होंगे।
अब सिर्फ ब्लॉक करने से कुछ नहीं होता। मैं हर बार स्पैम को फोन पे ब्लॉक करती हूँ, लेकिन ये बार बार आता ही रहता है। आप जितना चाहे ब्लॉक कर लो, इन स्पैम कॉलर्स को नहीं रोक पाओगे। मतलब इसका कुछ तो सोल्यूशन होगा। सोल्यूशन है, जब भी स्पैम कॉल आए उसे ट्राई DND ऐप या अपने मोबाइल ऑपरेटर ऐप।
We are not going to have parallel proceedings.
I have one due process of
experience.
Sorry?
The High Court by looking at prior experience again.
That is a different issue. It does not come.
Yes. High Court is considering the constitutional validity, not the same thing.
One of the so far as
we are closing all matters.
Here,
You are the villain of the piece.
One conclusion I have made.
Don't allow to High Court additional seating, Lordship.
There was a findings division bench regarding the teaching experience which has been given, that has been sanctioned by the division bench. Then one Orunima Pal was the unsuccessful candidate.
She was a tainted candidate.
No, my lord. Why the School Service Commission is interested in this matter?
Proposing everything against her.
Arunima Paul, I dismissed. I didn't
Yes.
Exactly.
Why the SSC is so much concerned?
Exactly, I'm saying that.
Kindly just Lordship,
hear me for
19.25, I take untied Lordship from this.
who was unsuccessful in 2016 selection process.
But she was not even selected.
Yes. Not even selected. Now, in 2025, he challenged that. Against that.
Perhaps you have changed
What
it.
is that? No. Please, kindly allow. No.
Why? No, the High Court is considering the constitutionality of the rules.
Kindly,
let the High Court decide the matter.
Kindly just hear me, Miller.
The decibel levels work at the Supreme Court.
Miller, kindly just hear me, Miller. Just 2 minutes.
Yes.
Without any interruption. Then your lordship will dismiss my contents. I have no difficulty.
2 minutes. Start now.
2 minutes. Just 2 minutes.
Yes.
Unsuccessful. 2016, 2025, they sat. They became again unsuccessful. They challenged the division bench judgment, where the division bench upheld the provisions of the teaching experience, right? And against that, SLP has been filed. Your lordship dismissed that. Therefore, those who are saying
You
about
need to also see what the locus of that person was.
No.
We did not say anything on the merits of the matter. So your dismissal of the matter does not mean that all principles in that judgment have been upheld.
Yes.
Because therefore, all of you go back to the High Court.
Lordships are not deciding the para 47. Para 47. We are on the next category. We are not on the para 47.
You've been allowed to join, is it?
No. I have a small request.
They can argue before the High Court.
Let that not be disposed of by this order in 19.
47 is people who are wanting
One
to
set
go back
is
to
not
their earlier job.
joined already, one removed and then came back for this, my lord. Your lordship permitted them to go back to their respective departments.
Within the state of West Bengal.
Yes. Now, my lord, we represent about 30-40 people, my lord. What has happened with them is simultaneously, after they joined in this, my lord, simultaneously they got appointment orders from one other different department of the West Bengal itself. Since they have joined and there was no case pending at that point of time, they could not join the other department, but they continued here.
That's going beyond.
Now today I am left with no remedy. We are all age
kind of candidate.
Cover that situation where
we
want the offer of another job which you never joined.
There are vacancies.
We also permitted you to go back to the job that you left.
We are placed similarly.
Similarly,
How you offer? You can
go back to the High Court.
Just withdraw here and go back to the High Court.
You won't say anything, whatever you wish to say before the High Court.
Please withdraw these plans.
On High Court.
19.15, 19.16, I'll withdraw. 19.15 and 16.
19.15, 16.
19.1.
All of us will say that, Lord. Same order.
Moana, which one do you want?
19.9 to 19.23. I appeal.
19.9
to 19.
All of them.
Yes.
All of them. With
liberty to
approach the High Court.
Approach the High
Court. The same relief.
For seeking redressal.
One more thing, Lord, the findings in the judgment of the court should not be in the way.
Yes.
We won't say anything.
19.1, 19.8 also.
19.1.
All same one.
19.15 and 16.
19.15
and 19.16.
19.38. 19.38.
19.27, my lord.
19.27.
Just there is one clarification, my lord, would be needed because now after the result, they have published a list only by name and the list of tainted candidates are there. Now it is very difficult to find out.
High Court is seized of that.
Your Lordship, just
Once the High Court is seized of that issue, then
May I make one suggestion on the High Court? On the High Court,
we'll make a
Your Lordship in
clarification.
November 23 had
19.27.
Yes, Ms. Makija.
Lordships have said that 31st December, the exercise must finish, Your Lordships. Now, unfortunately, I've just given this list. There are more than 70 matters which have been filed in the High Court.
That of course will have to.
Lordships, let me finish. Where different aspects, there's hair splitting, different aspects are being challenged. I have no problems in the matters remaining pending. All that I'm saying to Your Lordships is that matters can go on, but let no interim orders be passed.
Yes.
Court hasn't passed any interim order. Why is that?
Continue
Court hasn't passed any interim order. Honorable Supreme Court cannot be.
The tainted candidates have gotten through, they can't get
Yes.
No tainted candidate.
No.
Other matters which need to be withdrawn.
suggestion on the High Court. When we will
Withdrawal matters anymore.
Now we will get decision also more.
19.25, Your Lordship, 19.25.
Now we will decision.
If you want to withdraw, say so. No, you're not pursuing it here.
Para 47 of the Lordship.
Para 47 orders have already been implemented.
I'm working in the autonomous body in Kendriya Vidyalaya Sansthan. They are not.
Where are you?
Bengal.
Why is he not returned to his?
No, we have given everyone. We have
He's
given.
in Kendriya Vidyalaya.
Central government is not our government.
Central government perhaps is not a party. We have only said the government, which means the state government. State government and autonomous body. Autonomous body, Kendriya Vidyalaya is a central government organization. It's not an autonomous body. It is not an autonomous body.
Plus, can we, on going back to the High Court, may I make a suggestion, Milord? Your Lordships in November 23, when your
It's a
Lordships
different
have
issue.
order.
You'll have to go back to
There are a
the.
lot of matters that your Lordships can see. There are a lot of matters, a lot of issues. Your Lordships want to send everything back to the High Court. Very well. Because in November 23, when my Lords had passed a similar order at the interim stage, my Lords had said go before division bench and hear it expeditiously. My Lords may pass a similar order this time, so the matter can be heard finally.
No.
Just one prayer, my lord.
That's all now. Let us dictate the order.
Pass
The order.
Yes.
Your Lordship, will your Lordship be, your
should
Lordship
continue,
please to
my
take
lord.
up the intervention applications in item
You should
19?
be permitted to continue, my lord, till the time allocated.
No further order, no further order. High Court will please
All issues to address.
will be heard by the High Court.
Yes.
Will your Lordship be pleased to take up the intervention applications, your Lordship, in item 19?
Go before the High Court and by this because we blend the state government and bodies which come under the state government.
No, just 1 minute, my lord. High Court, I go there. We will approach the High Court in 2 weeks' time. Kindly protect us.
Your Lordship,
2 weeks, kindly give us protection.
Your Lordship,
Approach the High Court.
will your Lordship be pleased to take up the intervention applications in item 19, your Lordship?
8 of 2025 has already been entertained by a learned judge of the Calcutta High Court, and various issues were flagged by the learned judge in the order. What is the date of this order?
There are various orders, Your Lordship.
19/11/2025.
Yes.
The matters pending before this court as on date were kept. The matters on pending.
My lord, and
Matters on file before this court as on date were kept pending. You got the sentence. The matters on the file of this court as on date were kept pending only for the purpose of verifying as to whether or not the directions of this court in the judgment dated 3/4/2025 in state of West Bengal versus Baisakhi were being implemented scrupulously. As we now find that a learned judge of the Calcutta High Court has taken up that issue we are of the opinion that it would be appropriate that the High Court, being the court of the first instance, undertakes this exercise instead of this court.
Yes.
It would be open to all the petitioners, public applicants before this court to approach the High Court for redressal of their grievances
Yes, ma'am.
in accordance with law.
However, the selection process which is underway will not be stopped, Your Lordships.
We will not say anything.
That-
We will not-
Nothing.
The High Court
What sort of prayer is made?
fix the time-
Direction,
That's
We have fixed the time frame. As and when they come with an extension petition, then you can open.
I should have
Yes.
stopped to any selection.
I'm deeply obliged.
Your Lordship, be kind enough to take up the intervention applications, Your Lordship, impeachment applications are item
They've already
19.
got an order.
Through. None of the tainted candidates are permitted to slip through
11th November, 12th November.
during the fresh selection, be it on one pretext or the other. The High Court shall also ensure that the list of tainted candidates is placed in the public domain.
Yes, yes.
With full details, with full details.
Grateful, grateful.
So as to ensure that
And
this does not
unselected
happen.
candidates should get the benefit of 7 years. Lordship.
Your Lordships, it will be Lordships to say that the process should not be stopped.
When it comes to seek to read more into certain aspects of the judgment dated P4/2025 would also be at liberty to raise such hermeneutics, HERMENEUTICS, before the High Court.
Your Lordship said that
Your Lordships have referred to an earlier order, the single judge's order. Well, Lords, against that, there are several other orders. There is an order of 12th of November.
19th November.
11th November.
11th November.
I want those also. Same learned judge. 11th November, 12th November, 19th November.
11th November, 12th. Order.
20th November.
In those orders also issues are being flagged.
All issues and
Fourth time, my lord.
7th, 12th and 19th.
7th,
11th,
12th.
7th, 11th, 12th and 19th.
And the judge is hearing all the issues.
Dates of successful candidates also so that it can be compared, right?
7, 11, 12,
Compare this.
Compare what?
7, 11,
Those who have succeeded in the exam.
19.
Why would we want the untainted candidates to be looked at?
Well,
That's unnecessary.
able to know
Unless the High Court is now on a time frame, they have to complete it as.
The matter is fixed on 28.
Your Lordship, be kind enough to take up the intervention applications, Your Lordship.
And the applications
Yes.
are disposed of in the.
Deeply obliged. Deeply obliged.
Consider saying uninfluenced in our future.
Like this will ultimately bring them back into questions.
High Court can look into it. Matters uninfluenced by.
Yes.
Yes.
Any of the observations on merits made by this court in the earlier orders.
One more.
And one more line, Lordship, kindly add one more line.
One more
Untainted
section is now
candidates.
take out of.
We've already withdrawn various matters. You want to withdraw?
Lordship, these are the cancer patients. We have claimed the similar relief orders on humanitarian grounds.
That
was refused by the court.
Cancer patients and all that. We only said dealt with physically disabled candidates. Soma Das was a blind. Cancer and blind. She was a physically
The
disabled.
court categorically held Soma's case will not be applicable.
She was a physically disabled candidate too. She might have had cancer also, but she was within our scope only as a physically disabled candidate.
Because the matter is listed day after. This order may be uploaded today. It's listed day after.
Uploaded today.
Very great.
Deeply obliged.
Go before the High Court, please.
Extremely obliged to the Honorable Court.
If Your Lordship may be kind enough, Your Lordship, in item 19.
Go before the High Court.
Now vacate.
Already given
Space
that.
space for others.
My lords, your court will now empty out, my lords.
Yes.
Lordship, insofar as.
Your Lordship, in item 19, the intervention applications.
Actually, the first item, we were permitted to
participate on account of the old qualification 45. Lordships may clarify that
You've already challenged those rules.
No.
was repelled by the High Court.
We succeeded in an appeal and then we are here, my lords.
The High Court shall also be mindful of the fact that the
21st August.
untainted candidates during the past selection were allowed to sit for the exams.
In terms of this court.
So for the selections afresh, to be held afresh, and their candidature cannot be adversely affected by application of the new rules. Which
Grateful.
And one more line, Lordship. I want
to the untainted candidates would be
Untainted two candidates, they have faced examinations.
These untainted candidates will get the benefit of 7 years.
to read them out.
No. Why?
They have appointed.
If I say
Therefore, lordships may retain this matter.
You come up with these new rules and you try to.
And they will permanent in their job.
Because of
Kindly add this
our
line.
order, there's
Kindly, yes.
Item 19 may be retained, my lords. Because of
And 21 also, my lord.
Not this to anywhere.
In item number 19.25.
We have given
Kuleshwar Ahmed.
10 marks for experience.
So you'll be giving them all 10.
All.
The teachers, untainted teachers, you'll be giving them.
We are all untainted.
At what stage?
Will you be giving 10 marks to all?
10 marks if he has
Weighted.
for first year, 2 marks. If they completed 5 years, 10 marks.
Well, 2019 was.
All of them
are 5 years.
Yes, now we want.
Yes,
Now
that is the reason why we asked them, you are benefited by this.
No.
We want gold.
Just decibel is that side higher.
Now you have the microphone.
Now what has happened in the written examination? Some of the untainted teachers have secured only 26 and 30 marks.
And 7.
So they get these 10 marks though.
Even they have added 10 marks. Even educational qualification 10 marks. Even in that case, they are
not selected, they're not.
They are less than fresh candidates. Yes, marks are less than fresh candidates.
We are not.
Therefore, if I also say that all untainted teachers have to be allowed, then it is.
We have not said they will be allowed. We said that you will
disqualified.
Adversely affect them with
Their previous experience should be counted, Lordship.
this 50%, 45% we cannot apply.
Yes.
Too much. This is too wide because pressures are also coming within this commission. Arey bhai, what
Sir, आपको समझ में नहीं आया मेरे को.
but this new rules will be applied also to the freshers.
No.
New rules will not be easy.
To me, freshers and
when we asked to undertake the selection of fresh, we did not contemplate we will add new vacancies and bring in fresh.
Yes.
The intention was that you could hold a fresh selection for these untainted.
Yes,
You
but
enlarged the scope
Lordship,
now. You brought
Lordship,
fresh vacancies.
untainted candidates, Lordship,
So
their
you
previous
asked for
benefit
this
should be
on
added,
top of
Lordship.
that, you bring in new rules. Then once you bring in new rules, it can only apply to new selectees. It
That High
cannot
Court
apply
affair is
to people
pending.
whose selection has been set aside and they've been given another go. That doesn't mean that you apply the new rules to them.
But your lordships have said to appear in
Nonetheless, let this matters be now argued before the High Court. Why is
selection
wasting?
would start.
Giving of 10 marks to untainted
If
candidates,
an
that is
examination, a selected candidate, the untainted
Where
candidate
did you ask
should be
us
added, Lordship.
permission to frame new rules and apply it to the
Yes,
untainted candidates?
to create all trouble.
Did you ask for that?
they have, we have.
You've done that. So far as these untainted candidates are concerned, their candidature shall not be adversely affected
Yes.
by application of these new rules.
Mother, then in that case,
Deeply obliged.
that
Greatly obliged. Greatly obliged.
candidates who has secured lesser marks than the first
That selection, whatever you wish
That
to do, you do that.
is go by the rules. Go by the rules. It doesn't go by the interpretation.
clarify that.
That is all. That is all.
As such,
That's all, that's all.
Test after 10 years.
That's all.
Yes.
That's
Lordship,
let
item 19, Your Lordship.
High Court is considering the matter. Let the High Court do it.
Nothing. We've said that the untainted candidates.
Lordship, kindly add one line, Lordship, in order. Their previous.
My
Lord will
Lordship, item 19, Lordship.
End it now.
Your Lordship, I have an intervention application, Your Lordship, on item 19.
About it, and then all publicly come back to me.
We all want to be heard by your lordship, my lords, always.
No.
We always want to be heard.
We've not said anything about that. Why should she say anything? You sensitize the High Court that they are great.
I am ready to learn whatever your lordship says. I think your lordship declared that all tainted candidates will be taken into the employment.
Tainted candidate.
Untainted.
You said tainted.
Well, whatever is there in the order, no further clarification is necessary.
It should be separate hearing, Your Lordship.
No.
You didn't say untainted.
Untainted. Is your lordship's desire that
Well, the SSC is much interested to see that the corruption again gaps.
in a competition they are lesser marks.
In fact, not they should have held a separate selection for us. They didn't do it actually.
Next matter.
Your Lordship, and item.
Because we are grateful, my lords.
Next matter. Yes.
Appearance be given physically.
Yes.
7 maybe.
19.37 also. 0.38. 38. Oh, he doesn't want this piece. 37. 27.
24 is of the same one.
24, you want to withdraw?
No, this is the same one.
Same one.
24.
24, same one.
20. 20 council has come in or still battling at the door?
What is empty now?
Yes.
And no more sweat, Your Lord.
But then what Mr. Gopal Subramaniam is equal to all of us.
Now you'll be elegantly addressed by Mr. Subramaniam, my lords.
That's why it said one is equal to all.
And the football rabble-rousers are going to leave, my lords.
Sorry?
The football rabble-rousers. My lords, we gave you the atmosphere of Mohan Bagan versus Mohammedan Sporting. It was like you were in West Bengal. Grateful, my lords.
Yes, 20. Yes.
Please, Your Lordships. Look, the issue is a short one as far as the.
It wouldn't be short with you appearing, Mr. Subramanian.
Not, I try to be as concise as possible.
There are cross appeals, my lord.
Yes.
One issue, my lord, they have succeeded on the other issue, my lord, we have succeeded, my lord.
Yeah.
Look, there are two appeals.
Yes.
That is Civil Appeal 9701
Yes.
of 2025. My lord, I beg to appear for the appellant in that appeal.
Yes.
Hey, you wanted to meet?
I wanted to propose to you.
The XUV 3XO, but different.
Will you be my business partner?
Different is in the XUV 3XO RevX series, starting at rupees 8.94 lakh.
কারণ শর্মাজির ছেলের থেকে কিছু শেখো নাসাতে রকেট সায়েন্টিস্ট ইয়েস এমন কোনো কোশ্চেন নেই যার আনসার ওর জানা নেই
ও রিয়েলি তাহলে তো এটাও জানো যে প্রাণ পোটাটা চিপস না বিস্কিট
বল বল
এটা
পারবে পারবে
চিপস না বিস্কিট কি এটা কেন নাসাতে শেখায়নি বাবা বাছাই করা আলু আর স্পাইসি সিজনিং এ প্রাণ পোটাটা চিপস না বিস্কিট খেয়ে বুঝে নাও
I respectfully submit, my lord, the question which is answered against us, my lord. Just give me a second. If, my lord, we address your lordship on that point, my lord, the issue, my lord, which is decided against them will become irrelevant. So in case your lordships would like to hear that point first, I leave it to your lordships, my lord.
But may I just set out my facts, then I'll be in your lordship's hands. Let me lay out the facts, and then after that, Lord, your lordships may take over. Lord, let me straight away bring to your lordship's attention what happened in this case. My lord, there are two entities who are involved in this matter. One of them, my lord, is called ESL, and the other, my lord, is ECL. I'm just, my lord, using an acronym
Yes.
for the purpose of convenience.
Yes.
My lord, ESL, if your lordships will see, it has a slightly longer name.
Electro steels.
That's right, my lord. Your lordships will notice that it is Electro Steels Limited, ESL, which is the principal borrower.
Yes.
Electro Steel Castings Limited is, my lord, the party whom I am pursuing.
Yes.
And according to me, my lord, it is a guarantor. And there exists, my lord, a contract of guarantee, which can be subjected to the regime in the IBC. So, my lord, everything really revolves around the question whether there is such a relationship as a guarantor, whether a contract of guarantee is discernible, and if it is so, then, my lord, logically, the applications are maintainable. The NCLT, my lord, came to the conclusion, after examining the various documents in question, that a contract of guarantee was not made out, and therefore the application was incompetent. My lord, in the appeal before the National Company Law Appellate Tribunal, the Appellate Tribunal, my lord, concurs with that for slightly different reasons, but, my lord, reverses a finding and says that in fact there is no extinguishment of liability on account of the resolution plan, because, my lord, various reservations are contained in a resolution plan, that this does not in any way impact or impinge upon the liability of a guarantor, liability towards a guarantor. Well, this is just the broad view which I wanted to place for your lordship's consideration.
Yes.
Now, my lord, let me place some documents, because ultimately, my lord, under section 126 of the Contract Act, we have to examine, my lord, what is the law and how has it been defined. My lord, I must say, there is a distinction which is often drawn between guarantees which are called on-demand guarantees, like, my lord, bank guarantees, which on site you are meant to pay the money, which is guaranteed. And you also have, my lord, what are called guarantees, which really are intended to ensure the performance of an obligation. These, my lord, are colloquially called in English judgments as to see guarantees. That is, you ensure the performance of an obligation on whose behalf you are an obligor. So, my lord, the expression obligor or the word guarantor, my lord, these are all words. But ultimately, your lordships would have to see that is there an element of undertaking? Is there an element of voluntariness? That in the event that there is a default, then this person will do what is required to remedy the situation, that that person will not be in default. So, my lord, if the extent, if I may say so, of assistance or obligation which is undertaken by the obligor is coextensive with what was the obligation under the contract of the principal borrower, then, my lord, it amounts to a guarantee. Now, my lord, this is the real question which arises. My lord, there is a recent pronouncement of this court. There was a question, my lord, again under the IBC. There, my lord, it was styled as a deed of hypothecation. And the court examined the question. It may be christened as a deed of hypothecation, but if it has the constituent elements of section 126, we will not hesitate to treat it as a contract of guarantee. So, my lord, it appears from, I'm just stating the principle, I will make it good with reference to many of these judgments, but, my lord, it is, suffice it to say, the nomenclature, my lord, does not really decide the issue. It is the constitutive elements of a guarantee which must be discernible, and if they are discernible, then, my lord, notwithstanding, shall we say, pleading, notwithstanding for the matter of fact, my lord, something said which is inconsistent with it may not necessarily decide the issue. It is, my lord, preponderant evidence of the presence of these elements which will lead to the existence of a contract of guarantee. Now, my lord, that's the burden which I have to take for the purpose of succeeding in this appeal.
Yes.
So, my lord, may I take your lordships to the various documents, because I will take them in a chronological manner, And your lordships will then come to a view whether they militate against the existence of a guarantee. Well, the first document is Annexure A2, which is the sanction letter, which your lordships will find is in volume 1, your lordships printed page 204.
Yes.
So, my lord, I'm using a soft copy, but I have also noted down in the notebook, my lord.
We are old timers. We use hard copies.
That might be.
So,
just add, Lord. My friend said he lay down the facts.
oh, Mr. Mehta has vanished.
No, he'll be here. He'll be here. Lord, it is